Hello, I'm Shannon Piper. I'm with the marketing team here at Lexipol. I'm really pleased to welcome everybody today to the first in our police reform webinar series. As you all know, police reform is really just a very hot topic today. It's very controversial as well. And I think one of the things that makes it controversial is that it has different meanings for different people and different audiences. And what we're trying to do with this series, whether you attend this one event or all three of the webinars that we'll be bringing to you, is really to help law enforcement leaders better understand how to engage in discussions around police reform. So we're hoping that you'll be able to take some tools away to think about how to work best with your community so that we can really together achieve the end goals of reform without getting sidelined in changes or reform measures that really don't achieve the tactics and the end goals that we're all going for, because we've seen many instances where that has happened. So in this first webinar, we're focused on use of force and specifically the difference between policy and tactics. And is it right to be targeting policy for those changes, or are we really, when it gets down to it, talking about tactical things? So we'll get into all of that. Excuse me. And then future sessions are going to focus on response to people in crisis, which is another thing where we've seen incidents kind of spiral out of control and result in tragedy. And then our final session will focus on training artifacts and really examining whether training is setting our officers up for success, or if there are some things that we could be doing to improve that. A couple of just brief notes before we jump into today's session. We are recording the session and we'll send you an email by the end of the day today. It'll have a link where you can access that recording, and you can feel free to share the recording with anybody. We encourage you to do that. We are going to hopefully have some time for questions at the end. Please submit your questions anytime during the webinar, and those you can do that in the webinar console. You should see a questions field there, and we'll get to some of those as we have time. We're also providing a certificate of attendance today. You'll receive that via a separate email by the end of the day as well. And if you have any questions about this webinar, about your certificate, you don't receive the recording link, etc., just reach out to us at webinars@lexipol.com. And then a final thing here, this is not meant to be any sort of legal advice in our session today. You're going to be hearing from two attorneys, but this is an educational session, so please keep that in mind. If you're thinking about any specifics to your personal situation, you want to make sure to seek legal counsel. We're also going to be looking at some examples, some real world examples, some videos, and we don't have specialized knowledge or inside information about those cases. We're really looking at what's been published in the media and publicly through the agencies. So keep that in mind too as you go through this session. And I do see a question popped up about dates for the future trainings. There is a link in your chat field. It's the second link. I apologize. I put an incorrect link in first. The second link in your chat field will take you to a page where you'll see the dates for the other trainings, and also have an opportunity to register for those as well. All right, it's my pleasure to introduce Laura and Mike, your presenters today. Chief Mike Rinaldi is, he was a police chief in Glenville Police Department in New York for about 10 years, and prior to that served his entire career with the Colony Police Department, also in New York, and he held multiple ranks there, including patrol officer, sergeant, detective sergeant, and lieutenant. We are so lucky to have Mike as a program manager here at Lexipol. He does a ton of things. If I had to explain it succinctly, I would say he helps agencies implement our policies at their level. Mike is an attorney, as I mentioned, and a frequent presenter on various legal issues in law enforcement. He's also a graduate of the 2009 FBI Mid-Atlantic Law Enforcement Executive Development Seminar and a certified force science analyst. So welcome, Mike.
Thank you. Hello, everyone.
Laura Scarry is a partner with the law firm of Diano and Scarry and an attorney here at Lexipol. She also served as a police officer in the city of Lake Forest, Illinois, and she has since built her law practice representing police officers, police administrators, and the agencies they work for. And her practice covers a lot of different law enforcement issues, including things like use of force, failure to train, duty to protect, First Amendment issues, etc. And a large part of Laura's practice also involves representing police officers in the immediate aftermath of officer-involved shootings and other critical incidents. So, and Laura, you are also a certified force science analyst, correct?
That is correct.
Yeah, sorry, I missed that. Okay, well, welcome to you as well. And I will start by turning this over to Mike.
All right. Well, hello, all 2,000 plus people that have decided to join us today. Very happy with the turnout, and we hope that you'll all leave with something of value here. So we just want to, before we get into the meat and potatoes here, just want to kind of go over a few things with you. Number one, I want to reinforce some of what Shannon said about what this series is and what we're hoping to do. So we know that we're delivering this, amid a call for police reform, right? National call for police reform. It's been a rough year for law enforcement. It's been a very rough year for a variety of reasons, between COVID and all the police officers that lost their life last year because of that, and now with the turmoil and things that you're all facing every day on the road. So just want to start and hope I'll finish by saying thank you all for sticking with it and doing your jobs. But in the concept of reform, Laura and I when we talk about these things and working for Lexipol, we view reform as more continuous improvement. All right. Mm-hmm. So it's not necessarily, this isn't something that we in our careers teach and write about and act about. It's not something just because of what has happened over this past year after the Floyd incident. And this is the way, what we believe in. So we can call it police reform or we can call it improvement. It doesn't matter. But we want officers to do the right things for the right reasons. So, there's a lot of things that we can't control and you can't control out there. So what we do, though, in the concept of reform, we do want to focus on what we as a profession can, what tools I hope that we can share with you, or what thoughts, what ideas, and what things that you can put in practice. So, but we do have to at least acknowledge in this current climate that there are the things that you can't control. The things that you can't control are the fact that when people defy lawful orders and resist legitimate commands, they have dramatically increased the risk of involved in that contact. We cannot control that many people feel empowered to defy the police because of the disrespect cast upon the profession really for some time now. We cannot control that some people feel empowered and justified to assault and harm police officers. We see these every day, and they're not in the mainstream media, but people do recognize what you do and the risks that you are facing. With that said, there are things that we can do in this profession to control and to improve. So we'd like to have, as part of this, starting today and going forward for the other two, and who knows, maybe some more down the road, trying to dump more work on Laura and Shannon as much as we possibly can. But we do want to have a candid conversation with you. We're not here to tell you what we think you want to hear. We're telling you what we believe, because this is what we do. We believe you need to hear. Now, nobody should sit there and take everything we say as gospel. That's not the point of this. The point of this is, for nothing else, to get you to think. Please open your minds and think about some of the things we're talking about. Specifically, it is our belief, and as we will go through with this series, that there are tactics, strategies that have been used by officers that have in part contributed to this climate. And if you're not capable of considering that as a possibility, then I don't know what to tell you. But then continuous improvement will be difficult for you, because part of being a leader, part of being a professional is the ability for self-reflection, to really look hard and fast at yourself and be willing to accept the fact that it is possible we might have done something wrong and we can improve it. So, but again, more on that, guys, as folks, as we go through. But we are going to focus on some contemporary cases to try and reinforce the importance of understanding the difference between should you listen to the reform calls for reform to your use of force policy. Would changing the use of force policy actually change many incidents that have occurred? And as you'll see as we go through, we don't feel they would. That would. And we will explain all this for you, and hopefully have some time at the end to answer any questions that you may have for anything that we have not covered. So we want to do this because we want you to be able to and help to teach you how to do an effective root cause analysis so that you can look at tragedies, not tragedies within your own department, we hope, but these national incidents, and look at them and say, is there something we can learn from this? How would we have done this? How would we have expected our officers to respond or behave under these circumstances? And have we given them the tools? Or is it necessary for us to reinforce our policies with additional training, supervision, discipline? What do we need to do to make sure that those things can't happen here? So we need to focus on the things that you can control. We had asked in the landing page for this webinar that if people hadn't seen the webinar that Laura and I had done previously last year on duty to intercede, we asked that you would please take a look at it, because we are going to be kind of zipping by some concepts that we developed there. One of them, communication, and specifically the concept of crew resource management, teamwork, when you have discretionary time, actually communicating with each other and trying to make the best plan, because no one person can ever be expected to know how to handle every situation the best they possibly can. And the reality is, as we talked about during that, every once in a while, it's necessary to have to intervene and maybe tap an officer out. And for those of you that have seen it, know what we're talking about there. So with that said, let's jump right into the concept of legitimacy. Now, this is something that I know for me personally, I have used this slide in virtually every training that I've done now for years, because this is the way I functioned. This is the analysis that I used as a police chief, as a supervisor, as a police chief, and there's the attorney part of it in there. And I use it now also when I do occasional expert witness work. So when we look at an incident, we can't just look at it from the perspective of law, right? Laura and I are lawyers, we teach law. We want you to understand. When I go to a class and I teach a basic school or I teach in service someplace, you know, yes, I want people to understand the law. But law enforcement's not just about enforcing the law. And more important, it's understand this concept of legitimacy as we are presenting it to you. And that is that from a decision-making perspective, it's not only has to be legal, but it has to be the right thing to do. And there's some critical components there. The first thing I want to see, as when I was a chief, as a supervisor, and when I was as an attorney, were you legal? Where you had a right to be when this all started, when the incident started. Folks, that's like the base of the defense. That's the foundation. That and if you have a problem with that, then there's going to be a problem with the incident. Safe. Are you doing it as safe as possible? You're in law enforcement. There is no such thing as safe per se. But when you recognize and utilize an effective priority of life and only put yourself at risk when that risk is necessary to protect the life of another person, then that's what we're talking about. When that risk that you're placing yourself in, and potentially somebody else, is justified by the goals and objectives for the actions that you're trying to attain. are there community complaints and buy-in that has been attained if you're trying to enforce particular laws that may create some controversy? Is your response proportionate to what the problem actually is? So we firmly believe that if you do something as legal as possible, you're doing it as safe as possible, and vice versa, whether you realize it or not. We're going to talk about opportunity in a little while as one of the components of justification for use of force. Opportunity means, are you putting yourself, and specifically we're going to be asking you, are you putting yourself at risk unnecessarily, or are you doing it for a legitimate reason? Neither of us believe that. I have never met, I've been in law enforcement my entire adult life, and I have never met another police officer that ever had any desire to hurt anyone. And I believe that is 99 point whatever percent of law enforcement out there. But what I have seen, and we both will be talking about, are situations where officers put themselves, including me, in my past, at risk for illegitimate reasons. It wasn't justified. And I don't mean illegal, I just mean under the guise of officer safety, we thought we were doing something safely, but in the reality is it wasn't. So now, what do we do? How do we, how can, let me try that again. Let me give you guys an example of this. Let's take a traffic stop incident that occurred. Now, I just have some screenshots that we'll go through fairly quickly, but you'll get a feel for this. So the officer stops a car for a equipment violation, and he approaches the vehicle and starts the conversation in the same way that I was trained 36, 37 years ago now. License, registration, insurance card, please. Well, why are you stopping me, officer? If you just give me your paperwork, I'll explain everything once you have your paperwork, right? That's what I was trained to do. I was told that is what you got to control. You're in control of the traffic stop. You have to do that. Well, it didn't go well in many circumstances. So anyway, in this particular incident, the officer just refused. He absolutely refused to tell the person why he had stopped him until he had the paperwork. So it went on for a little while. He still refuses, so they're at a standstill. Neither one's given in. And then finally, from a procedural standpoint, now the officer had already been off with this car for a period of time, but now he decides that he better call off with it and let dispatch know where he is. But standoff continues. So then he ends up asking for additional units, which arrive. But his only attempt at persuasion of the driver is to tell him that if he doesn't comply, he's going to get arrested. So backup arrives. There's no verbal interaction between the officers at all. There's some nonverbal communication when they take out their gloves and start strapping on their gloves, so we know what's going to happen at this point. But there's no discussion, folks. And again, I'm going to refer you back to the duty to intercede webinar where we talked about what would it hurt at this point to take a step back and talk to each other and have one of the officers say, look, man, just tell him. If that's the problem, just tell him, right? And then maybe the other officer would have said, oh, yeah, what the hell? We don't need to go through this. But they didn't. He pulled the window out, and then he fell backwards, almost into the path of an oncoming vehicle. You can see there. And why? Because now he's pumped up, right? He's into this incident. He has tunnel vision or selective attention. So now focusing on the task at hand, and that's pulling the driver out. So, which is what they do, and essentially the fight is on. Now, listen, Shannon mentioned this earlier, and I'll say it again. I do not mean any disrespect to the police officers. I was trained in the same way. And I will say this flat out. In many, I can't speak for all states, but I know in New York, this would be legal. This would be legal, right? If the person refuses to provide the paperwork, at some point, we are allowed to turn things into a full custodial arrest. But is it really, it's legal, but is it legitimate? Is it really necessary? Is the officer here really in control? And if you want to define control by, well, control means the person making the arrest as compared to getting arrested. That's not really what it is from a behavioral perspective. The driver was calling the shots here. So the question that we will talk about several times throughout, numerous times throughout this webinar and then the future webinars is, take a minute to consider the perspective of the other person. What if this was you? What if this was a family member that was out someplace and they're not afforded the courtesy of someone telling them why they're being stopped and what is going on? So, and the other issue too is, like, for me, and Laura, please chime in here, but I know I could just hear if somebody like Laura had reached out to me and said, Mike, I'd like you to evaluate a case. It's a use of force case at a traffic stop. I would look at it and I would say, okay, tell me what you want me to zoom in on. What do you want me to clarify? What are you going to say?
Yeah, it's and by the way, Mike, I just realized something, and we may have started our law enforcement careers at around the same time. So I actually started about 35 years ago, and you're right. That's the way you were trained, and I have to tell you, that's exactly how I was trained. When we're on a traffic stop, we're supposed to be in control, and the driver of the car is supposed to listen to us. And then when you go through this, the slides demonstrating this particular incident, this really hit home for me because I actually was hired to represent a municipality and a police officer as a result of a traffic stop, and it was a legitimate traffic stop. But what ended up happening, and it was all captured on the squad car camera, eventually the driver was asked to step out of the car, and the driver continued to ask the police officer, my client, well, why are you stopping me? And every single time that question was asked, my client responded, please give me your driver's license. And that's all he said. So then the driver says again, well, what are you stopping me for? I have a right to know. Please give me your driver's license. So the officer was polite, but he was monotone. He was robotic, and he wasn't communicating with the motorist. So what ended up happening is, there was a lawsuit that followed, and while the traffic stop was lawful, the interaction was lawful. But, as an attorney, what I have to do is I have to weigh what a jury's going to think about this. And I can't remember the number of times that this transpired, or the number of times, this dialogue, not a dialogue, but the driver would ask, what'd you stop me for? And then the officer would respond, well, please give me your driver's license. I think it happened between 25 and 35 times. And there was absolutely no communication. So in this case, it was a lawful traffic stop. It was a lawful interaction, but was it the right way to do it? So I think this is kind of a great platform for us to get started on how we can do our jobs better as law enforcement officers. So thanks for letting me, chime in on that.
Yeah, and it really all flows around taking perspective into consideration. And
right.
For me, then as a police chief, if this was my officers, and now I'm going to walk into a press conference, say, to talk about this, and now as an occasional expert witness, and also as a trainer under both roles, the question's going to be this: why wouldn't the officer just tell him? That's
exactly.
going to be the and folks. Legitimacy is not met by, that's just the way I was trained. So, again, we don't mean to beat up on this particular incident and everything, but we're just trying to set the tone for what we're describing as the process here and as we're going to go forward. So let me just talk for a minute on officer safety. And when we talk about officer safety, anybody that's been in my classes know that I have a far more expansive definition of officer safety, because it's not just about, like for instance, these officers may have walked away from this incident, or again, not to keep picking on them or whatever you want to call it, but in any incident, you may leave it physically safe, but when the incident itself doesn't appear legitimate, then what happens? The viral videos and the news coverage and how that impacts your long-term mental wellness. You have enough to worry about with what you see, and the external issues from both the personal and the departmental perspective, your image, your reputation, your community impact. And it's not just about the officer in many cases. It's also frequently about the family, because the kids are getting involved in school where people are, other kids are picking on them and giving them a hard time. And then look, literally it's listed last because it is last. Liability is not the concern, not the initial concern with what we're trying to do here, but it is something that is impacted. And also the fact of being involved with a lawsuit, I'll let Laura build on that in a minute here, but it's not good for many officers. So now we need to balance this out by meeting this need for full officer safety by using priority of life, by using discretionary time when it's available, by utilizing effective communication through the process that we suggest you at least consider, that the concept of crew resource management that keeps the planes that you fly in up in the air when they're perfectly good, or on an operating table. And be open-minded and be willing to listen to somebody say, dude, just tell them, right? Or look, back away. We're way too close to this guy in dealing with somebody that's a threat. And what does all this lead to? All of this leads to constitutional policing. So
Yeah. I'm sorry, Mike.
No, go ahead, Laura.
So I agree with you that part of the discussion has to include other important issues, such as the negative impact on our communities, particularly when it comes to litigation. Obviously, the more litigation a particular community has, the less trusting its members are of the police. And let's not forget about the fiscal toll litigation can have on the community's resources. So obviously, there's no way to completely avoid litigation from occurring, but we can certainly improve the way we do business in an attempt to minimize potential litigation. So I guess we can go to the next slide here and speak. So speaking of litigation, I want to spend just a few minutes on the seminal case of Graham versus Connor. And really, every sworn police officer must understand this case, because it's all about determining whether an officer's use of force, whether it's less than lethal or less lethal and deadly force, it's determining whether that force is reasonable under the totality of the circumstances the officer was confronted with at the time the force was used. If officers understand what makes any level of force reasonable, whether it involves handcuffing a person, using a taser, or applying deadly force, the officer will be able to defend his actions in a court of law. And as a reminder, in determining the reasonableness of the officer's use of force, the courts are going to consider several factors. And these are not the only factors that courts will consider, but these are the factors that the United States Supreme Court focused on in their decision in 1989 when this case was decided. The courts are going to focus on the severity of the crime at issue. Are we dealing with somebody who has a license plate light out, or are we dealing with a person who's wanted on murder? We're going to look at the threat of the suspect, we're going to focus on the threat of the suspect posing to other officers and the officer himself that's involved, or other individuals who may be around the scene. We're going to look at whether the suspect is actively resisting or attempting to evade arrest by flight. And unfortunately, though, despite the determination that an officer's use of force was reasonable in a court of law, the court of public opinion has become the driving force in the calls for change in department policies and the law, particularly in cases that are characterized as lawful but awful. And, you know, we spent a couple of minutes at the beginning of this presentation talking about, you know, that the traffic stop in the slides. It was a lawful traffic stop, but my goodness, it's awful when you present it to a jury. Then if we look at one of the myths that involves police reform, Shannon, if you go to the next slide, please. One of the myths involving police reform is that it is possible to change behavior and control a police officer's action merely by placing more restrictive language in policy. And unfortunately, that's exactly what we're seeing today, a push for change to use our use of force policies by including or adding more restrictive language into the policies. For example, we're seeing some policies actually list specific circumstances under which an officer can use force. It's bad for business. But the reality of human performance under stress is that the officer might not be able to follow those restrictive guidelines or even recall in the aftermath the guidelines in the first place under stressful circumstances. By not understanding this, communities may think that changing the policy is the answer, but in reality, it actually creates false expectations for our communities. Now, what's interesting, given my experiences in representing law enforcement officers, and it's been within the last 25 years, and reading hundreds, maybe thousands of cases involving the use of force, the Graham analysis actually only covers a very tiny sliver of time during an incident. At the moment in time that an officer used force or deadly force, was the officer or third party at risk of death or serious physical injury? Under a strict Graham analysis, no 20/20 hindsight is allowed, and tactics do not even come into consideration in making that determination. And Graham is sound. It's been around since 1989. It is one of the most eloquently written court decisions by the Supreme Court, and hopefully it's going to remain the law. But we need to focus more on the pre-use of force actions. We can do a better job as a profession by doing that. Now, lay people simply do not understand the difference between the pre-force or the pre-seizure conduct and the actual use of force. And the result is a call for more restrictive use of force policies or changes in the laws. We're seeing that today based on, you know, some of the high-profile incidents. And for law enforcement, it's critical that we understand the difference and fix what we can control in an effort to save the profession.
So yeah, and I just want to add, and I want to go back for a second to, and I mean not in the slides, but just to finish up with that incident on the traffic stop, and just to add another concept. Now, I call it the power of right. So what we're describing is, you know, this is a Rinaldiism, as these things have been called, but to put the power of right on your side. So, in other words, like with an incident like that, you have somebody refusing, you tell them, you know, that's the right thing to do. So you tell them exactly, sir, okay, now the person still refuses, right? Because that's what people are going to say. Oh, they're still going to refuse. Okay, I found that in my first department, when we switched to that process, and it's not just about traffic stops, it's about anytime you contact somebody, explaining why you're talking to them and so forth. But, and it cut down on personnel complaints, it cut down on bad interactions. But anyway, the point is that, you know, sir, I've explained to you why it stopped. You're legally obligated to provide your paperwork, et cetera. You go through and you explain. You go, sir, here's what's going to happen. If you just cooperate with me, we'll write you the ticket. You'll be on your way. You can plead not guilty. We can go to court, but you'll be on your way and it's over with for now. However, if you don't, I have the right to arrest you. I really don't want to do that, et cetera, right? I'm not going to go through the whole thing, but what you're doing by doing that is you're transferring the decision to the person. You're you're saying everything that is legally correct, and you're making, this is how you can control. So you put the decision as to what's going to happen next onto that person. It's the respectful thing to do. It's the right thing to do. And in many circumstances, it'll avoid the contact. And we'll talk more about this in the subsequent webinars as well, but it takes into consideration the person's perspective. And then you can say, look, I got the right on my side. I've done everything I can do to enforce the law. All right, so let's go through, let's start another example here, another incident. This is Dontre Hamilton. He was a person, he was a homeless person. He had suffered from mental illness in Milwaukee. The police department had contacts with him, and he was in a park, a public park. Police were called on him. A couple officers came, checked on him, spoke with him briefly, called back in service. He was in a public place and he wasn't doing anything wrong. Another officer decided that he was going to check on him as well after those two officers left and returned to service. So he approaches Dontre and he recognizes him. And so I'll just go through the incident quickly, and then I'll explain what's up here on the scene. So he approaches him. He knows who Dontre is. He tells him to stand and put his arms out at his side, and he comes up behind him and he starts to pat him down. Excuse me. Dontre at some point decided no and started to fight with the officer. The officer took out his baton, tried to use it to subdue Dontre. Dontre took it away from him and now attacked the officer with it. The officer then responded by shooting him and unfortunately killed him. Now, from a Graham perspective, as Laura described, was the officer, or this is the ultimate Graham issue. Was the officer or a third person at risk of serious physical injury or death at the moment in time that the force was used? And the answer here is clearly yes. That the baton was a dangerous weapon being used that could easily kill him. So lawful, the shooting part. I've taught search and seizure, and here in New York, we have very, very restrictive street encounter laws, but it's my belief that anywhere in the country, this frisk would be considered illegal. So from a legitimacy standpoint, we're starting from a bad spot, because the fact, having prior knowledge that somebody's mentally ill, yes, he knew that he had tried to harm himself previously, and I believe that involved a knife. But a prior incident like that is not sufficient to justify a frisk, right? So again, I'm not trying to turn this into a legal thing, but so the chief suspended and eventually fired the officer for policy violations, both for the frisk and also for not following his training with defensive tactics. However, what this quote on the screen here is the officer involved explaining why he felt it necessary to frisk Dontre by himself. He was describing how another officer had explained to him, oh yes, it did involve a knife because he had stabbed himself in the neck. And the other officer had told the involved officer that Hamilton seemed to be extremely disturbed. He had a 1,000-yard stare, extremely paranoid, very, very muscular build. And that if the other officer had been by himself, he most definitely would have overpowered him, or pretty much any officer I can think of, to tell you the truth. He was just that big, that muscular. I would say he would be impossible to control if you were one man. So folks, I want you to consider that. That is what the officer is using as his explanation why he moved in by himself and put his hands on a mentally known person struggling from mental illness who could be dangerous. So let's go to the next slide, Shannon. So what's the root cause here? Let's go back to our myth. Would having a laundry list of when deadly force was justified and when it was not, would having a more restrictive above and beyond Graham versus Connor, would that have prevented, I'm sorry, would that have prevented him from contacting him in the first place in the manner in which he did? No, it wouldn't have. Is it right to allow somebody then to kill a police officer, but in other words, not allowing that police officer to use force to legitimately defend himself when he's being attacked? Because bad tactics or not, police officers have a right to live. So the point is, a more restrictive use of force policy would not have prevented this. Instead, the root cause of this is somewhere residing in training, somewhere residing in supervision and possibly discipline, or somewhere in all three, meaning that there was a failure at some level in those points. Did this officer, or was it just the officer himself? So the question that has to be asked in situations like this is, would other officers in our agency have handled this the same way? And if the answer is yes, then you have potentially an organizational issue that needs to be addressed through training and supervision. If the answer is no, this is just the kind of stuff that he was known for doing, then we have a supervisory problem, because if he's known for doing that type of stuff, he should have been corrected. But here's what we do know. 2 officers came, handled the situation properly, and left. Then he came and did what he did. So he failed to consider, he failed to consider the perspective of how somebody suffering from mental illness, already having been contacted by police officers, might react to being touched and searched. And also from a legitimacy purpose, I already mentioned it probably was not legally justified, but also look at the risk the officer put himself into. So now let's develop that a little bit further, because let's look at what happens to a police officer when they're attacked like that. So we've used this in other webinars. I did a webinar with Bill Lewinsky from Force Science, and we talked about these concepts. But very quickly, what the Yerkes-Dodson curve, inverted curve, represents is that it shows that up in the top part of this U, that is when human beings can perform the best. They have a moderate amount of adrenaline, cortisol, epinephrine that's been released into their system because of the stress that's perceived, what has happened to them. And therefore, that's the optimal, that's the sweet spot. That's where you actually are your best, capable of your best performance, physical, and you're still able to use much of your mental skills. Fine motor skills start to be compromised earlier, but then the next slide shows what happens though in a situation like the Hamilton case. So the officer may come into this somewhere on the rise, okay, some level of arousal. Then starts to frisk. Then all of a sudden he's attacked. Now what this shows, and as you see, there's a cliff there. That's a catastrophic loss of gross motor skills. And also, you're now relying solely on what is burned into your amygdala, your training, your amygdala, your hippocampus, and your training. You're fighting for your life. You're no longer making decisions. And this is where, once you get to this point, I'm just giving you my opinion. It's impossible for any human being at this level of stress and arousal to be able to now sit there and think about a written policy that restricts him or her from using force under all these circumstances. It's just not going to happen, folks. You're going to react the way you have been trained. Threat and you're going to respond. So this is not where you want to be. So how do you avoid that time distance cover, right? That's a big one. But now let's go to the next slide and look at this a different way. Look at this another way. And I'm going to take you back to law school. I'm not law school.
No.
I know when I have too much work going on, right? Because I wake up, I have dreams in the middle of the night that I'm in law school and I've skipped class for an entire semester and I have final exams and I don't know what classroom to go to. I don't know where my locker is. I don't know where anything is. So I'm losing my mind. So while I gather my mind, no, Lori, did you want to add anything before I go on into this slide?
No, go ahead. Yeah.
All right. So many of you probably saw some version of this, what's depicted on the screen in your police basic school, and maybe in subsequent training since then. Some of you may have seen like a triangle where they'll have the sides, intent, jeopardy, opportunity, and ability. So these are the three factors that are generally used, at least in my entire career. This is the way I was taught it way back in, back then. And when these three are separate, no force, no deadly force, nothing is justified. However, when these three all come together, when a person has evidenced intent or jeopardy, in other words, regardless of what their intent is, the actions that they're taking are dangerous to someone or something, some persons, they have the ability to do it. And this is what we're focusing on. They have the opportunity to do it. So now, let's go back to the Hamilton incident. Could Dauntre have filled these three together at any time? Sure, he could have. And we don't know if he would have or not, because that's not what happened. But that goes to the point that these are not always in the control of the officer, folks. We're not trying to imply that you guys are overtly, not trying to any implication that you always control this. You do not always control this. However, there are times, and we started with this, from our experience, we know that there are times where officers do put themselves in a situation where they have given the person the opportunity. So when you recognize that, then you need to try and change it. And you need to pull that opportunity away. So now let's touch on the duty to intercede webinar. Let's say that an officer is a little overextended and maybe is doing something that's putting him or herself at risk. If another officer comes in, this process of pulling that opportunity away may be the result of that next arriving officer tapping the person out, saying, come on, back. Come on, man, we got to get some space here. Just back up. So whether the elements of intent and ability existed when Dauntre was first contacted, we don't know. But when he did move in to frisk him, when he chose to move in to frisk him, the opportunity now was there for Dauntre to take advantage of. That's the root cause of this incident. That's the root cause of this problem. I'm not going to say that Dauntre would not have attacked him anyway. Can't do that. But interviewing Dauntre from a distance, a little safer distance, maybe with a bench in front, in between them. Anyway, time, distance, cover. That's what can give you the ability to pull that opportunity away. So now let's just one final point on this, folks. And most people on this call are probably familiar with what has been dubbed the 21-foot rule, the Tooler rule. It's not a rule. It's not hard and fast. It's a very valuable training concept, because essentially what it says is that if a person is within a certain distance, I'm not going to pin it down to the 21 feet because there's all kinds of articles out there about, it could be less, it could be more. But the point being that, say, from an edged weapon perspective, that person can get to an officer before the officer will have the opportunity to draw their weapon and effectively fire that weapon. So again, we're not going to get into the overall discussion of it, but I think everybody on the call would understand what that means. That means that you really shouldn't allow yourself to get into that area when somebody has the intent, apparent intent or possible intent, and the ability. The last thing you want to do under the 21-foot rule is provide that opportunity if you can help it. So action versus reaction. I'm sorry, again, in other classes we've talked about this, but you don't win. You tie maybe, but you don't win. And in this particular case, he ended up fighting for his life. So, but anyway, with that understanding, what's the root cause? Why would a person with all that background, why would a person say that for officer safety, they needed to conduct that frisk? So we'll probably talk more about the 21-foot rule in the subsequent webinars as they pertain to those incidents. But right now, let's just jump into a video. And before we play it, I just want to set the stage for you here. This is a shooting that occurred. Tatiana Jefferson was in her house in her I believe it was her sister's house. It doesn't matter, a relative's house, playing video games with her nephew. A neighbor across the street knew that the regular resident of the house had been having some medical conditions. This was at nighttime. Saw the cars were there and that the door was open, the lights were on, and he called the police and asked for a welfare check because this normally didn't happen. So anyway, you're going to see a little blip here while Shannon starts the video.
PM and 42 seconds. The body camera video shows the officer checking the front door of the house. You see the screen door closed, but the front door is open. From there, the officer walks to the right, to the east side of the house. You can see the white car parked under the carport. The officer walks up to the side door. That screen door there is also closed, but the main door, again, is open. So the officer can see into the house. When the officer gets to the back of the house, there's a blue car parked in front of the garage. He turns on his flashlight and checks the gate to the backyard. That's at 2:32 a.m. and 24 seconds. It's been 42 seconds since he checked the front door, and he has not identified himself as a police officer. At 2:32 a.m. and 48 seconds, the officer opens the gate and walks into the backyard. You see the air conditioning unit at the back of the house there. Just 8 seconds later, you see the officer walk to the window at the back of the house. Tatiana Jefferson is standing on the other side of that window. You hear the officer yell, "Put your hands up, let me see your hands."
Put your hands up, show me your hands.
He immediately fires the single shot through the window, killing Tatiana.
So I'm not going to sit here and pretend to know all the facts and circumstances of this. The officers are awaiting trial. Again, our perspective here is not, or our purpose here is not to vilify anyone. I don't know why the officer did what he did, but I want you all to consider this. You know, first off, is there anything in your training or your procedures that would allow some of your own officers perhaps to have this apparent heightened level of feeling that there could be something going on here? I don't know. I don't know how to explain it, but I do know this. His actions may have been taken with the thought that he was being safe because he's a police officer, right? I can do this. I can walk around this house. I'm on a call. I have that authority. I can do this. There's police on the side here. But what he failed to take into consideration is the perspective of the people inside. And for all of you on this call, what would you do if you're at home or if you're at a friend's house and you saw somebody sneaking around outside and looking in your windows? I'm guessing there would be some movement towards your weapon, because otherwise, why do you have it, right? I mean, you're home and there's somebody walking around outside your house, you know, then let's say one of your loved ones or whatever are shot and killed or injured, and then you're told, sorry, the officer's actions were objectively reasonable. That's the stuff that gets people angry at us. And we, by taking in perspective and understanding, could there have been some element of risk at knocking on the front door? I guess, I don't know, but we can't be crippled by that. So there's too much unknown about this. We'll see. Maybe something will come out at the trial that, you know, none of us know, but it just still leads to the point of consider perspective, and that it could, the perspective of the people on the receiving end of your decisions, could that be increasing the risk to you? So, Laura?
Yeah, so speaking of which, let's talk about another case that was actually decided by the Supreme Court in 2017, and that's the County of Los Angeles versus Mendez. And in this particular case, it involved LA County Sheriff's deputies, and they were looking for Mr. Odell, who was a parolee at large. And a confidential informant said that, or reported that he saw someone that fit the description of Mr. Odell, who was riding a bicycle in front of several residences, including the residence of Ms. Paula Hughes. And the deputies, in response to that notification, they held a briefing, and they were advised that there would be a shack in the backyard of the main residence of Ms. Hughes's house, where two people had actually lived. And those two people were Angel and Jennifer Mendez. Now, Ms. Mendez was a girlfriend at the time of the incident, but she has since married Angel Mendez. And so there was a plan to search the premises, and it was set in motion, but no warrant had been obtained to search the main residence or the shack in the back of the property. And two deputies were tasked with searching the shack, and they proceeded to do so with weapons drawn because they expected to find Mr. Odell somewhere on the property, and he was determined to be armed and dangerous. So when everybody went to the location, officers went to the front of the residence, and as I indicated earlier, two deputies were tasked with searching the rear. They entered the shack without knocking or announcing their presence. Angel and Jennifer were sleeping on a futon, and apparently there was a BB gun that was on the futon where they were lying down. And by the way, Jennifer was some months pregnant. So he moved the BB gun to put it on the floor in an effort to get up. But while doing so, he pointed the BB gun in the general direction of the two deputies. And of course, what do you think happens? The deputies shoot in the direction of where they saw the firearm being pointed at them, seriously injuring both of the Mendezes. They both lived. They received significant injuries. It's my understanding that Angel had received 10 shots. As a result, one of his legs had to be amputated below the knee, and the pregnant Jennifer was shot in the back, and I believe she was shot in the hand. And it's interesting because I had not actually seen a photograph of what this shack looked like. And Shannon, if you can go to the next slide, this is an actual photograph of the structure. And you'll see that it doesn't look much like a residence, but there were indicators that indicated that it was an actual residence. The structure was made out of wood and plywood. There was a single doorway that was covered by a blanket or some sort of a tarp, and I believe that you can see that blue object on top of the structure. There was also an electrical cord that ran into the shack, and if you look very closely at the picture, you'll see in the lower right-hand corner that it appears to be a power cord of some sort going to the shack, and there was an air conditioner that was mounted on the side of this what I will characterize as a flimsy structure. There was also a gym locker that was located in close proximity to the structure with clothes and other possessions inside the locker and also near the shack. So anyway, that's the residence that was the subject of this incident. And as a result, the Mendezes filed a lawsuit against the county and the deputies, and they alleged 3 separate Fourth Amendment claims against them. The first claim against the deputies involved a claim that that they conducted an unreasonable search by entering the residence without a warrant. So we'll call that the unlawful entry claim. The second claim was against the deputies for performing an unreasonable search by failing to knock and announce their presence. So we'll call that the knock and announce claim. And then finally, the deputies were accused of using excessive force by shooting them, the Mendezes, after entering the shack. So we'll call that the use of force claim. And interestingly, the case was heard at trial, but it was before a judge as opposed to a jury trial. So this case was actually decided by the district court as a result of bench trial. And the court found that the deputies were liable on all 3 claims, including the excessive force claim. But with respect to the excessive force claim, what's interesting is the court found that at the time of the shooting, the deputies' use of force was reasonable, given their belief that a man was holding a firearm threatening their lives. However, the unique thing about the Ninth Circuit was that the analysis could not end there because of this rule, again, that's unique to the Ninth Circuit, and is called the provocation rule, which holds that an officer's otherwise reasonable and lawful defensive use of force is unreasonable as a matter of law if, first, the officer intentionally or recklessly provoked a violent response, and 2, that provocation is an independent constitutional violation. So going to the next slide, the case went up to the United States Supreme Court, and the issue presented to the Supreme Court was whether the Ninth Circuit's provocation rule is consistent with the Fourth Amendment jurisprudence, particularly with respect to Graham versus Connor. And the Supreme Court held that it was not. It specifically noted that by conflating the claims of excessive force with other Fourth Amendment claims, in this case, the unlawful entry, the provocation rule allows excessive force claims that cannot succeed on their own terms. In other words, in this case, the lower court found that the use of force was reasonable on its own. It was only when considering the separate unconstitutional claim of the unlawful entry that the district court found the deputies used excessive force, and the Supreme Court found that that was improper. So the Supreme Court vacated the lower court decision and remanded the case to decide whether the Mendezes could recover damages for their shooting injuries under the separate unlawful entry claim. In other words, whether in a federal case, an incident giving rise to a reasonable use of force is an intervening, superseding event which breaks the chain of causation from a prior unlawful entry in violation of the Fourth Amendment. So another way to look at this is to say that an improper entry is actionable by itself as a Fourth Amendment violation, and it requires its own proximate cause analysis, which is why the case was remanded to the Ninth Circuit. So going to the next slide, and I know this is a lot of legal mumbo jumbo, but it's important for you all to understand that, we can't conflate, or the courts typically are not going to conflate separate constitutional claims with some exception, and we'll get to that in a minute. So on remand, the Ninth Circuit Court found that all of the courts involved in this case had agreed that the entry into the property without a warrant or without consent or without any existing exigent circumstances violated the Fourth Amendment. And in analyzing this claim, the Ninth Circuit ruled the unlawful entry was the proximate cause of the Mendez's injuries, supporting a federal constitutional violation. In other words, had the deputies not unlawfully entered the property, the plaintiffs would not have been shot while lying in bed based on the evidence before the court. Stated another way, unlawful entry invites violence, particularly in situations where the occupants do not know that the invaders are police officers. And that's what the record reflected in this case. It's important to note the Ninth Circuit reasoned that the officers could not even have obtained a warrant to search the shack or even the main house because a wanted parolee riding a bike near many houses, including Mrs. Hughes' house, simply doesn't amount to probable cause. And the court also went on to rule that the officer's reckless behavior in not obtaining a warrant, entering illegally, and not knocking and announcing allowed for a finding of negligence under California's state negligence law. So we can go to the next slide because I know, Mike, you have a couple of talking points on this.
Yeah, this slide, folks, is super important to read and understand. And we normally try not to put big quotes like this in, but this language needs to be read, understood, and remembered. And because essentially what the court is saying is that, yep, officers, yep, you remind us all the time that you're required to make split-second decisions in very difficult situations, and that can lead to an officer on alert, weapon drawn, result in shooting injuries where the officer mistakes an innocent implement for a weapon. Yep, you tell us that. But entry poses a foreseeable and severe risk only partly mitigated by knocking and announcing. And what they're saying is, you guys want to keep saying that, which is true, right? This is all true. What the court is saying, you keep saying it, that's fine. We'll accept that. But you better only do it when you're legally justified in doing it. And in this particular case, when we talk about what's the root cause of this, what's the problem, the root causational factor, it was the decision to enter without a warrant. And there were multiple people involved with this. So from a crew resource management perspective, again, if you look back to what that concept does for the airline industry, this was a controlled flight into terrain, right? There should not have happened. If somebody, and that's the term from that discussion, but this shouldn't have happened. Somebody should have spoken up. This is what Laura and I talked about in the last webinar with the duty to intercede. Somebody should have said, look, guys, we need to get a warrant here. Let's go knock and talk. But, you know, other than that, why are we going to put ourselves at risk and also everybody else there for this? All right, so let's appreciate everybody's attention here, where I know we're going a little bit over, but just very quickly, I'll buzz right through the White v. Pauley case here. So this was, it started out as a road rage incident. And the caller, this Pauley brother, this Pauley is involved in a road rage incident with these women. They pull to the side of the road, they have their verbal exchange, he leaves. They call the police, he drives home, the police come, they give the officers the license plate. They find that he lives right off the highway that they're on. So they interview the ladies and they realize, and this is really important, there will be no charges filed on this. That there's no crime here. It's just people getting angry at each other for whatever really super legitimate reason. And so, but regardless of that, the officers decide to go ahead and interview Pauley. Okay, that was their decision. That's fine. I don't know all the facts, but here's where the problem started. When they got to the property, they decided to park in the street and decide to do a stealth approach by approaching with their flashlights off and only occasionally use their lights shielded as they walked up the driveway. And I'll show you what I think is the right driveway in a minute here. But so, well, the guys inside, the Pauley brothers, see them coming, right? They see somebody sneaking up the driveway, but they allegedly do not know who they are because it's dark, it's rainy. So they indicate that they're armed, and they say, hey, and the officers yell back. Again, there's dispute over what was said, and they said, well, we're coming in, and they said, we're armed, you better not come in, and then they fire a shotgun blast as a warning. Anyway, long and short of it, this goes on for a minute or so. This officer is hiding behind a stone wall, sees one of the brothers pop out with a gun, pointing it in his direction, and he shoots and kills him. So this, the next slide shows what I believe, and I'm just showing you this because I did my best to try and track down where this occurred, but it was difficult to do so. I believe it's either one of those two houses in the center back there, but again, I'm not positive. And Shannon, if you want to just go down to the next. Again, folks, I'm not. Oh, yeah, well, we jumped ahead there, but that's all right. So imagine coming up. Yep. All right, go ahead to the next. So imagine it's rainy and dark, and you're in your house. Once again, folks, where are we going with this? We're going back to perspective. And I also just want to point out, it's not our intent to sit here and use hindsight to rip these things apart. It's not. Look, there could have been something. We all do things. If these officers had actually communicated with each other and expressed valid reasons for the need to do an approach like this, well, then they followed what we're just talking about, communication, and do it. But I don't know what that would have been. No charges filed. So now, again, when you think about how many guns are in the United States, I thought I saw a stat of how many hundreds of million guns are in the United States. And once again, from their perspective, they were just involved with a road rage incident, and now somebody's sneaking up their driveway. So anyway, so I'm sorry, Laura, you want to?
No, yeah, that's all right. So when with respect to obviously the brother who lived ended up filing a lawsuit against the officers, and the lower court, and it's important for you all to understand that there was not a trial in this case. It was decided on a motion for summary judgment, and so all three officers, the two original officers that ended up walking to the house, and then the third officer, Officer White, who was behind the wall that eventually shot Samuel Pauly, they filed a motion for summary judgment and basically arguing that they were entitled to qualified immunity. And by the way, that's a big issue nowadays. Unfortunately, we don't have time to talk about that issue. That's for another, possibly a half a day webinar. But anyway, I digress. So the 10th Circuit affirmed the district court's denial of qualified immunity to the officers, concluding that a reasonable officer in Officer White's position would have known that since Samuel Pauly, the one who pointed the gun out the window, could not have shot him unless he moved from behind the stone wall. He could not have used deadly force without first warning Samuel Pauly to drop his weapon, and that this was the clearly established law at the time. So the case goes up to the United States Supreme Court, and the United States Supreme Court reversed and again reminded the Court of Appeals that the clearly established law is not a generality. Instead, in determining whether or not the law is clearly established, it must be particularized to the facts of the case. Now, that doesn't mean that the clearly established law requires a case that's directly on point. Instead, there must be a similar prior case that puts police officers on notice as to what the law is. And the Supreme Court emphasized that Tennessee versus Garner, which we should all be familiar with, and Graham versus Connor do not by themselves create clearly established law outside the obvious case. And this case was not such an obvious case. So the Supreme Court remanded the case back down to the lower court. And Shannon, if you go to the next slide, on remand to the 10th Circuit, the court felt that the reckless actions of the officers precipitated the threat made by the brothers, but it nevertheless granted qualified immunity to the officers because at the time of the incident, the officers were not on notice that under these circumstances, the law was clearly established that their conduct violated the Fourth Amendment. And unlike the Mendez case, where the Supreme Court took issue with the Ninth Circuit's provocation rule, which considered the pre-seizure conduct of police officers, in this case, the Pauley case, the only issue before the Supreme Court was whether, for qualified immunity purposes, the law was clearly established at the time of the shooting that the officers were put on notice that their conduct violated the Fourth Amendment. The Supreme Court in the Pauley case did not address whether it was proper for the 10th Circuit to consider the officers' pre-shooting conduct in determining whether the officers reasonably believed the Pauleys were a threat to the officers or others. So what does that mean for police officers in the 10th Circuit? Well, that means the courts, depending on the circumstances, are going to consider the pre-shooting or pre-seizure actions of police officers, which is why Mike and I think it's important that officers consider using appropriate police tactics or think about the appropriate police tactics, particularly in situations where officers have discretionary time. You know, and if you think about these cases that we're talking about, these cases involve the use of discretionary time by police officers. We're not talking about the sudden ambush or you know, things that are truly, you know, rapidly evolving. But in these types of cases, the officers have discretionary time. And please understand that poor tactics by police officers prior to a shooting do not automatically equate to a violation of a person's constitutional rights. However, it is something that the courts, at least in the 10th Circuit, will consider. That being said, despite the potential or lack of potential for liability, why wouldn't we want to improve on law enforcement tactics to minimize the risk of everyone involved? You know, not only from a safety standpoint, but even in an effort to minimize the risk of liability. So Mike, if you want to take the next slide.
And Laura, it just, you know, it's just another example of, you know, I touched on this before, you know, with the officers going up the driveway like that with, you know, look, if they had reason to believe that if they drove up the driveway, they'd get shot, then, well, then don't drive up the driveway. As a matter of fact, you're not going to arrest them anyway. So why are you even going to go? But my point is, we've got to get past this. Well, we're the police, we're on a call, we can do this, right? That's true to a point. But once again, you have to take that perspective of the person into consideration and make decisions that you're not, that are not going to put you at risk when you do this by failing, by allowing that we can do this because we're the police, right? We're on a call, we're investigating, so therefore, and we can choose the tactics we're going to take. You're right, you can. All that's accurate. But do it smart. Dynamic entries, warrants. Many of you on this call, on this webinar, don't, in some of your states, it's not an issue for you, right? You don't necessarily do many of them. Here in New York, I did a lot of them. And when I look back, I cringe, and I consider myself lucky. I mean, like this gentleman here, you know, it's hard to see in the screenshot there, but he has a golf club. And that the officers are doing a no-knock raid, or they smash in the front door. He comes running out with a golf club. Once again, back to the Jefferson case, you know, think of yourself. You're woken in the middle of the night, somebody's blasting in. What is your first reaction going to be? Again, guys, we're not saying don't do these. If you want to go to the next slide, Shannon, but we're not saying don't do these. What we're saying is that if you're going to do them, then follow that legitimacy pattern. You know, okay, first off, is it legal, right? Get the warrant, get the authorization. There are some states, I think maybe yours, Laura, where you can't even really get them. And you know, make sure it's legal to do it. Don't do this stupid, you know, oh, I knocked and now, you know, here's my knock and the ram going in the door. That's not a knock and announce. But they're dangerous to both of you. Are there alternatives? Your decision must be legitimate, legal, and the right thing to do. What's in that house that is so worth getting in there as compared to another alternative where, let's say, we can take the person off, the target off in a traffic stop someplace, and then go in when we believe the house is empty. So, you know, for you leaders out there, sometimes you have to tell your people, no, we're not going to do that. And just very quickly, my own personal experience, did a raid. Look, folks, I was a point man for 10 years, and I'm admitting this, and I didn't care, right? I didn't care what the raid was for. I just we trained for it. It was what we wanted to be used. So we did an entry on a house, and long and short of it, my I was 1 and 2 was on me. Our goal was to break left and move quickly to the back of the house. 3, 4, we're supposed to, so as you came in the door, there was a staircase here. Our job was to clear left, move quickly through. 3, 4, we're gonna go upstairs. 5, 6 behind us. 7, 8 up the stairs, right? Soon as we break and we're moving in the back, all of a sudden I hear yelling, drop the gun, drop the gun, drop the gun. The long and short of it, it took so long because it was steel cord door. It took so long, like 30, 45 seconds, somewhere in there, for the Ram or little Arnold to break down the door. It woke up the guy, the target, and he had been ripped off before, so he thought it was happening again. So unbeknownst to me, he's standing at the top of the stairs with a shotgun with his finger on the trigger. And the only thing, and afterwards he was shaking like a leaf when we brought him in and did a debrief on him. The guy was a wreck. The only thing that saved me was police on my vest. And you know, the lieutenant brought me in the office. And Laura, I'm sure you hate these conversations when they start out with, Mike, you're the lawyer. Oh boy, this isn't gonna go well. Tell me what was in that house that would be worth me going and knocking on your wife's door and telling her that you're dead and or seriously injured. The answer's not a damn thing. So when I took over the team, I had a whole different paradigm shift after that. And I realized that I'm not putting my people in that risk. And I'm not putting the people on the other side of the door who may legitimately feel that they're being victimized. So let's just sum this stuff up, folks. And again, we thank you for your patience and your attention here. But just behavioral change, especially with stress, is just not driven by the written word alone. I mean, I wish it was, you know, and that's what you just want to say to a lot of the critics. It's like, do you think if it was that easy, we would just do it?
Right.
But these situations are difficult. You know, legitimacy is a complex process, and we're going to try and tie it together for you with the remaining webinars. And if need be, we'll, you know, reevaluate what else we need to do. But so these concepts of people, policy, training, supervision, discipline, they're all important to help you define what the root cause is. And look, again, our intent is not to be overly critical and use hindsight and everything. But folks, these incidents, they're, as Laura pointed out, we're not saying that you're going to have liability because of all this, but that's not what's driving us. It's not the liabilities that's causing us to do this. It's you. It's your safety. It's your well-being. And remember that expansive definition of safety. It's not just about you. It's about your family, both your family at home and your family at work. So, Laura, anything?
Yeah, no, and please understand that we're not criticizing, you know, the officers ahead of us, you know, that have been involved in these lawsuits. You know, they've been the ones that we're learning from, and if we can learn from, you know, the good things that officers do, and the bad things that officers do, then we're helping, you know, the brothers and sisters in blue. And so these are all learning lessons. And Mike and I, as he indicated at the beginning of the presentation, you know, it's all about doing the job right, not just lawfully, but just the right way. And you know, and quite honestly, I think that it is a large part of the driving force of what's going on over the past year. So with that, I know we overextended, and again, as Mike said, we appreciate everyone, you know, staying on the call. I see that there were only a few people that dropped off, and Shannon, so I don't know if we're going to be taking any questions. You know, I leave that up to you. So with that, I'll turn it over to you, Shannon.
Sure. Thank you, Laura. Thank you, Mike. Just a great session. And yeah, we went over, but I think we had more that we could have said. I know we did. We did get a lot of comments and questions. I think, given the interest of time,
Okay.
rather than just taking a couple and calling it a day, I think what I'll do is I'll capture these. There were a lot of comments too that I think will inform Laura and Mike's next webinar, and maybe we can even talk about starting out with a couple questions if we think that's a way to do it for the next webinar. Start out with a couple questions from this webinar if we think that that's a way to go. But anyway, on your screen here is a link where you can find more information about this series. If you are only interested in today's event, that's fine. We're going to be posting the here today, and you can get the slides. But if you're also, we encourage you to, check out the other webinars too. The registration for both of those is open, and I believe the dates are March 30th and April 23rd, something like that. Trying to remember on my feet
Yeah,
here, but please check that out. And if you have any questions about this webinar, if there's anything specific you want Mike and Laura to consider, reach out to us at webinars@lexipol.com. We'll be sure to pass those comments along to them. Thank you just so much, Laura and Mike, for your great insight today, as well as everybody who's attending here today. And I think, yeah, let's leave it with a Renaliism and keep right on your side. Did I get that right, Mike?
So, yeah.
I like that. Yes, very good. Thank you,
All right,
Shannon.
well,
Thank you, Mike, and thank you everyone for attending this webinar.
Yes,
Thank
thank you
you.
all. Remember perspective.
Yes. Stay safe out there. Take care now.
Bye-bye.
Bye.